1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ118 Original Civil Jurisdiction Civil Miscellaneous number 94 of 1963 in the matter of the estate of CHIT deceased objectors versus Domamaji petitioner Unyontin for the petitioner Umyintin for the objectors Isiindong audiobook ko ထက်တန်းရှိနေဦးအောင်ခိုင်ဦးထက်တန်းရှိနေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှိနေဦးထင်လင်းဦးမိသားစုကစီစဉ်သည် Dr. Maumau Judge Domamaji the petitioner asks for a succession certificate to enable her to collect the benefits of a life insurance policy held by Uchitin, her deceased husband, with the Union Insurance Board. The objectors, sisters of the deceased, point out that the benefits of the policy had been validly assigned to them, and therefore they do not form part of the estate of Uchitin. The following are undisputed facts. Uchitin and Domamaji were married on 6 August 1957 before the third additional magistrate Rangoon as evidenced by the affidavit of marriage filed. Uchitin was married before to one Dosangwe, who later died. The objectors are the sisters of Uchitin. The life insurance policy was taken out by Uchitin on 1st March 1953. According to the evidence of Wu Mao, PW7 of the Union Insurance Board, who made his statements in court by reference to the files, the assignee of the policy was Do Sangwe, but on 15 May 1957, that assignment was cancelled and the names of the three objecting sisters were registered by Uchitin with the Union Insurance Board as the new assignees. The evidence of the sisters established that the fresh assignment was made after the death of the wife Dosangwe. Some 3 months after that, Uchitin married Domamaji, and on his death on 22nd July 1963, i.e. nearly 6 years after the marriage, the insurance policy still stood in the name of the sisters. Uchitin raised a loan for the Union Insurance Board on his policy and, according to Wu Angdan, PW5, from the Ministry of Finance and Revenue, where he worked as a superintendent. He paid the premium on the policy till his death. Thus, the policy was never abandoned or treated as paid up. It grew to maturity on his death. Normally, as the status of Domamaji is unchallenged, she will be entitled to a succession certificate should she need one, to collect from her late husband's estate. Her status is so clear and so widely accepted that she has been finding no need for a certificate in representing her late husband in his financial affairs, and Wu Angdan states that papers are being processed to pay out his pension and gratuity to her. In regard to the money payable under the insurance policy, however, Section 15(1) of the Union Insurance Board Act, as amended by Act 44 of 1960, stands in her way. The section reads, Sanga Te ဥပဒေနှင့်သော၎င်းဥပဒေကဲ့သို့ပင်အာဏာတည်သောဓလေ့ထုံးစံ၌သော၎င်းမိတို့ပင်ဆိုထားစေကမူဤဥပဒေအရပြုသည့်အသက်အာမခံ policy လွှဲပြောင်းပေးခြင်းမှာမပြုမနေရဖြစ်ရမည်ဖြင့်ဆိုခဲ့သည့်လွှဲပြောင်းပေးခြင်းသည်မိသည့်စည်းကမ်းချက်ပါရှိစေကမူဆိုခဲ့သည့်ဥပဒေကြောင့်သော၎င်းဆိုခဲ့သည့်ဓလေ့ထုံးစံကြောင့်သော၎င်းမပြတ်စေရချွင်းချက်က Kaji, Doyarin, Midazu Shido, E. Elbria, Amagan Tadu to Udi, Mimi, Midazuna, Mabada Dua, so get the Lebdown Beijingo, Mapuya. Kagwe, Tobien, Midazu to Zuma Shido, E. Elbria, Amagan Tadu to Udi, Midu Dramaso, so get the Lebdown Beijingo, Mimi the boy out, Pew 90. Ne. Pomagwe did Trinja Kagwe, Amagan Taduga, beauty together, Lebang Beijing, Todu Ena beauty near the Biana, a low liao, Piatti who, my Yuami. Don Amagan Tadudi, E. Elbria, beauty together, Lebang Beijingo, a Puega Piatandi, Sigan Jamia a dime, Pin 90, Domaho, Bepsat 90. As it is plainly set in section 15.1. Its provisions override any customary law that may apply to the estate of the deceased. Had it not been for this overriding force, the assignment would have been of no effect unless it strictly followed the rules of the inheritance or succession laid down by the customary law, in which case the assignment would have been redundant. In Doyu versus Sun Life Assurance Company, Canada, 1935 ANR, Rangoon, page 211. It was held, because such statutory provision was absent, that a nomination in a life insurance policy of a person to whom the amount should be payable on the death of the insured has no effect, as such a person is not a party to the contract of insurance. The insurance money forms of the estate of the deceased and is a debt due to his legal representatives. The insurance are bound to pay the legal representatives of the deceased and no one else. Though now that has been overcome by Section 15.1 of the Union Insurance Board Act, there are provisos to the section that somewhat restrict the liberty and preference of the assignor. If he has a family, he must assign the policy to one or more members of the family of his choice, but not to a stranger. If he has no family, he has full liberty to assign the policy to anyone he likes. If, however, after such an assignment he marries, then subsection 2 of section 15 comes into play and renders the assignment null and void. The intention of that subsection is clear enough. If a man has assigned his policy to a stranger and later marries, he may cancel the assignment himself under subsection 3 and make an express assignment to his wife. If he forgets or fails to do that, the law steps in and nullifies the assignment to the stranger, so that the benefits of the policy will return and remain in his estate. Unyontin, land advocate for the petitioner, argues with his usual ability that the assignments made to his sisters by CHIT were nullified on his remarriage by the operation of subsection 2 of section 15. Umyintin, land advocate for the objectors, claimed that the assignment came under proviso Kaji and was therefore untouched by the operation of subsection 2, which only applies to assignments made under proviso Kaji, i.e., those made in favor of strangers. This posed the question whether the sisters were members of Uchitin's family within the definition of section 2 Zagwe of the Act, or whether they fell outside that definition. Section 2 Zagwe of the Union Insurance Board Act reads as follows. Zagwe, Midazu Sodi Zagayatwe, Dit, E. Ubria Amaganta du the Jauja Pili, to the Ide Mayani Kalimia, 2.ဤဥပဒေအရအာမခံထားသူသည်မိန်းမဖြစ်လျင်ထိုသူ၏တရားဝင်လင်နှင့်ကလေးများ 3. ဤဥပဒေအရအာမခံထားသူ၏မိခင်ဖခင် 4. ဤဥပဒေအရအာမခံထားသူကမိခိုအားထားခဲ့ရသည့်သို့မဟုတ်၎င်းပေါ်တွင်မိခိုအားထားနေသည့်နီးစပ်သောဆွေမျိုးညာတိများပါဝင်သည် Clause 4 of the definition lays down two tests. One is the closeness of the blood tie and the other is dependence. As to test 1, there can be no dispute or doubt. The objectors are sisters of the full blood and that is close enough by any law or custom. The question of dependence is one of the evidence and both sides have led evidence to prove or disprove it. The sisters in their evidence have stated that they were and married. They lived together with CHIT who supported them, paid them 150 jets a month regularly, paid the rent and made other provisions as and when necessary. Even when CHIT's first wife was alive, they says they lived together and it was only on his remarriage that they parted, though CHIT continued to support them. They have tried to earn something in small trade, but their brother was their main support. They are supported by Captain Kokole, Utaton, Ukemau, and to some extent by Do Soyin, witness number 1 for the petitioner, who states that when the sisters were her tenants, CHIT was often seen at their house until one day they told her that their brother had moved away. The dependency required under Section 2 Zagwe 4 does not have to be total. It is left to be tested in each case in the plain and natural meaning of the definition to see whether a dependent qualifies under this clause. Unyonten invites me to look at the definition of dependent in the Workmen's Compensation Act by way of drawing an analogy, and Section 2(1)(d)(2) clearly brings an unmarried or widowed sister, if wholly or in part dependent on the earnings of a workman at the time of his death, within the definition. Thus, he, dependent, even as defined in the said Act, does not have to be whole. It can be partial. In the Union Insurance Board Act, however, no degree of dependence is laid down as the test, and the plain and natural meaning of the expression Miko Ata must be taken. The facts of this case can leave no doubt that the sisters qualified as members of the family of CHIT both by their dependence on him and also by their closeness in blood to him. It is interesting to note that the Union Insurance Board Act, originally enacted as Act number 16 of 1950, did not contain Clause 3 and 4 in Section 2 Zagwe. These were added by the amending Act number 44 of the same year. The intention of the lawmakers is therefore clear that the meaning of family should be enlarged and the parents of the policyholder as well as those close relatives on whom he was dependent or who dependent on his should be brought within the benefits of Section 15 of the Act. Section 15 Proviso Gaji was also amended by the later Act to make the benefits to an insurance policy available to members of the family. Proviso Gaji, before the amendment, read as follows. Change Gaji, though ya doing a now she do Amagan Tashi do the Udi, Mimi Bidazu Naimabado do a so get the Luebiang Pei Jingo, Dodimo, so get the Ami Twinta Jingo, Mapusia. The plain meaning of that proviso was that a man who had a wife could assign his policy in favor of the members of the family, but not to strangers. If a man had a family but not a wife, it will appear under the proviso that he will be free to assign his policy outside his family. The proviso Gaji, as it reads now, is clear that if a man has a family, as interpreted more widely under Section 2 Zagwe, then he cannot assign his policy to a stranger at all. Within the family, however, his choice of assignee is unrestricted. On the evidence, I find that the sisters were members of Uchittin's family within the meaning of Section 2 Zagwe of the Union Insurance Board Act. At the time, he assigned the life insurance policy to them. The assignment was therefore valid. It could have been disturbed by Uchittin himself cancelling the assignment, as he was at liberty to do under Section 15(3) of the Act. 6 years passed between the assignment and his death, and Uchittin, who, as Superintendent of the Ministry of Finance and Revenue, had experience of procedures, did not cancel the assignment made in favor of his sisters. It could not have been inadvertence on his part or oversight, for he risked a loan on the policy and paid premium for it till he died. He also knew he could cancel the assignment and make a fresh one, for when his first wife died, he had done that, nominating his sisters in the place of the deceased wife. The other way in which the assignment to the sisters could have been nullified was by operation of Section 15(2) of the Act, but this applies only to assignments made in favor of strangers at the time the assignor was unmarried. Here, the assignment was made under Section 15(1) Proviso Gaji and is not therefore couched by subsection 2. Unyoten argues that the validity of an assignment can only be fully tested at the time of the death of the policy holder, for that is the time when the policy becomes ripe for payment. Again, he draws an analogy with the Workmen's Compensation Act, where compensation becomes payable on the death of the workman. There, however, the death of the workman out of and in the course of his employment is the reason why compensation becomes payable. In the case of insurance, however, though the policy becomes payable on the death of the holder or on maturity in his lifetime, the reason why the money is payable is that he has been saving it up. The test of the validity of an assignment of an insurance policy must, therefore, be made at the time of the assignment. The Provident Funds Act probably provides a closer analogy to the Union Insurance Board Act in some regards. Section 5(1) of the Provident Funds Act protects the rights of nominees, where nominations are duly made in accordance with the rules, notwithstanding anything contained in any law for the time being in force of disposition, whether testamentary or otherwise, by a subscriber. This is an analogous to the provisions of Section 15 of the Union Insurance Board Act. The definition of dependent in the Provident Funds Act seems to be even more liberal, for it includes unmarried sisters, deceased sons, widow and child, etc., and does not require the actual facts of dependence. The relationship is all that Act goes by. Because of the reasonably close analogy between the Provident Fund Act and the Union Insurance Board Act, it may be useful to refer to the ruling in Edith Mary Haney versus Elan Florence Rodriguez and others, 1941, RLR, page 912. There sharp judge sitting on the original side of the late High Court and ruled that where a subscriber has a family within the meaning of the Burma Contributory Provident Fund rules, he cannot leave his Provident Fund to anyone outside the family. But if he has not a family, he is entitled to leave his fund to a charitable institution. The intention of the legislature is that a subscriber may have something on which to live when he retires. If he dies before he is able to enjoy his retirement, and if he has no family, then he has something to leave, and it matters not to whom he leaves it. The decision was upheld on appeal. Utemau of the Union Insurance Board, whom Unyonten was good enough to call as his witness on my suggestion, has given information relating to the policy in dispute and also useful information on the practice of the Union Insurance Board over the years in matters relating to assignments. He states that in applying Section 15 of the Act, the Board examines the application for assignments, and if the assignee is relative of the assignor, no questions are asked. The assignment is considered to be valid and duly registered. After that, the Board regards the assignee as the only person to whom it should pay out on the policy in the event of a policyholder's death. The Board does not investigate whether the assignee is dependent on the assignor, and if so, to what extent. When the assignment is made in favor of a stranger, then the Board satisfies itself that the assignor has no family, i.e., no wife or children and no relatives. This practice over the years, Utemau says, has not raised any problem, and in his experience in insurance business dating from 1938, this is the first time that contending claims between the widow of the deceased policyholder and the duly registered have been put up. In the circumstances, I must find that the assignment made by the late Uchitin in favor of his sisters still stands, and by virtue of Section 15(1) of the Union Insurance Board Act, the benefits under the policy fall outside his estate. The succession certificate cannot therefore be granted to his widow, who claims her interest under customary law or other statute law, which in this case is superseded by the Act. The application of Domamaji is therefore dismissed, as this decision has turned on some fine points of law. The parties will bear their own cost.